to order. Collection Service Board on March the 12th, Wednesday, 2014. Kimberly, would you give us the roll call, please?
Bart Howard,
Here.
Elizabeth Dixon,
Here.
Steve Harb,
Here.
Chip Hellman,
Here.
Elizabeth Trinkler.
Here.
All members are present, sir.
Thank you, ma'am. Kimberly, would you read us the notice of the meeting?
Yes, sir. This meeting's date, time, and location have been posted on the Collection Services Board's website and included as part of this year's meeting calendar since August 16th, 2013. The agenda for this month's meeting has been posted on the board's website since March 5th, 2014. This meeting has also been noticed on TN.gov's public meeting calendar. You're welcome.
Question of whether or not that company needed to be licensed and,
Mr. Howard, your mic. You've not been on.
my goodness.
There we
Okay.
go.
Do I start all over again?
No, I think we're
I
good.
think on tab 5 of the agenda has been removed because that agency that was requesting whether or not they should become licensed has indeed become licensed, so we've removed that. If we would review the agenda and if there's any questions or changes,
I make a motion we adopt the agenda.
Second.
moved and seconded that we adopt the agenda. All in favor?
Aye.
Minutes of the last meeting, we received those on my email. Are there any questions or additions to those minutes? If not, I'll entertain a motion that we accept those minutes.
We accept them, adopt them.
A motion's been made that we we accept the minutes of the January 8th meetings. Is there a second?
I second.
And seconded, all in favor?
Aye.
Okay. Motion carries. Legal report, Mr. Whitaker.
Thank you, Mr. Chairman. You should have before you on your iPads the legal report for this meeting. There are 31 items on here, and before we kind of get moving with that, just to draw your attention to a couple of big batches of complaints that are listed together because the description of them is identical. Items number 11 through 15 for these complaints, these are essentially what I like to call first go-round untimely surety bond folks. They, for various reasons, mostly due to their internal processes, did not get us the proof of surety bond coverage timely, but they got that turned around pretty quick. And board's prior practice has been for folks who have no prior complaints, who do in fact get the surety bond coverage in and there's no lapse, to give them a letter of warning the first time. And so that's the recommendation for items 11 through 15. And then on items 16 through 29, at some point around the Christmas holidays, there was in my mind, an unexplained delay for quite a large number of UPS packages that were supposed to have come to us. They did eventually arrive. I'm not sure, what alternate universe they were inhabiting for the time where they weren't here, but they were sent on time and they did get signed for. They just didn't get to the board staff before the complaints had been opened. But if you go back and look at the tracking information, the folks sent it on time. So the recommendation for all of those is going to be dismissal. The other items are listed individually with descriptions and recommendations as normal. So I'd like to take a few minutes to review that, and I'll be happy to entertain any questions.
And then read the complaints, each one of us. None? All right, are there any questions for Mr. Whitaker?
One question.
Sure.
There are a few cases in here where, and it appears an out-of-state agency has attempted to collect debts inside the state of Tennessee, and they're not licensed to do so. I could give you some examples, but I just want to ask you generally, are these coming from informed consumers that understand the law, or is there a consumer attorney out there that's raising this issue? Because I
Mr.
can't
Elmer.
imagine that consumers really, I mean, I guess they can't, are they that informed that they're smart enough to catch it's an out-of-state agency? They may not be licensed. I was just wondering the method that, are these coming from consumers?
Most of them actually are, with the advent of internet technology being what it is, and most of the complaint forms now being submitted online, since the consumers that are filing these have to go to the collection board's website anyway to get to the file a complaint part of things. The verify a license tab is, literally right next to it on the left. So, if they get far enough to file a complaint and they say, well, I wonder what verify a license is, click on that button, type in the name of the company
Okay.
that's been calling them, and if it pops up no records, then, they know or at least suspect that they don't have a license. Now, it's, every once in a while, they will type in like a DBA name or something, but the actual company itself that is in front of the DBA name is, has the license. And so occasionally you'll have something like that. But for the most part, for the complaints that you're referencing, these are from consumers, and, in addition to whatever beef they have with how the debt is being pursued, it looks like they've become savvy enough to click on the verify license tab and type in the company's name anyway.
Okay. And then the second question I have is kind of a weird one, but I was contacted by an out-of-state attorney probably 6 to 8 weeks ago who represents collection agencies, so it's that type of attorney, who indicated he had a client that had not properly renewed their license in Tennessee, and I gave him, of course, can't really engage in any of that discussion, so I gave him your name, number. Is there anything on this list that I need to abstain from? I really don't see it on there.
No,
I just
Mr.
want to
Hellman,
make sure that I don't.
None
Okay.
of those complaints ring any bells, and if this
Okay.
conversation you're referring to was anytime recently, to the extent it may be on there, it probably would not be up until the next meeting. So
I don't recognize it in any, but I just want to make sure that I don't vote on something that maybe where I might know the party. So,
Sure. Just,
Okay.
read the next legal report for the May meeting with a close eye as well.
Okay.
Just to see if anything sounds familiar, and when in doubt, just recuse yourself and be safe. And
yeah, that's what I was thinking. And of course, any of those types of conversations, I just pass them along to you or somebody here, because I don't want to get into those conversations. So,
if it's an attorney that you're dealing with, I certainly don't mind you passing them along to me, but if it's not an attorney, pass them to the board staff first, so that, because they may be able to address that question, especially if it's not a legal one. But if it turns out that it's a legal one, then they can always get it to me. So,
actually, it's never happened to me before this time, and it was an attorney, and so I thought, well,
that's
lawyer to
perfectly fine.
lawyer.
I'm happy to,
Okay.
happy to deal with them when and if such
Okay.
a person calls.
Thank you, Chris.
Yes, sir, Mr. Harper.
Number 5,
Yep.
I may have read it too fast, but the way I read number 5 is the person did not send a letter into Tennessee. They only sent Texas letters. And
That appears to be the case.
why are we giving them a cease and desist? From what? They didn't do anything wrong, it would seem. I'm just curious why we selected a cease and desist and not just dismiss it.
Well, actually, in this one, I'm going to propose an amendment for a letter of warning, because I think that's more appropriate. Only because the complainant, the address listed on his complaint form is a Tennessee address. Now, I'm not saying that he doesn't have, a Texas address. For all I know, he could have moved here and maybe still has a Texas driver's license or something. But just really, I'm shooting for something just on the record, so that this company knows, and the board is on record saying, hey, look, we understand that in this case, it looks like you were just sending to Texas, but just, this is a Tennessee resident, so please be mindful of, not sending to Tennessee, so that if this same entity comes back before us again, they can't say that we never said anything to them about sending stuff to Tennessee.
On number 8, let me look at it again. You go ahead first.
Well, it just, it says that this is against a non-licensed company, and then it says about revocation of the license.
Yeah, thank you. That was the same question.
So,
That's an excellent question, and typically that is stock language that I include for licensees, but because this is a non-licensee, that recommendation language will just need to be amended to say formal hearing with authority. So for the revocation will just need to be deleted, because that way we have the authority for the formal hearing and for the consent order with the civil penalty, but obviously you can't revoke something that doesn't exist. So I appreciate.
also not be a cease and desist to them?
I can include cease and desist language in the consent order, so it just kind of be all one thing.
I see that there's a pattern of no licenses, people collecting without a license. The verbiage of the actual complaints, do they seem to be kind of boilerplate? I know there used to be there may still be some websites that say if you owe a debt, call us and we'll help you out with it, and some kind of standard complaint letters coming in. Does it appear that that's what this is, or are they all different?
It really varies complaint to complaint, Mr. Chairman. I've seen a handful that really look like somebody copied and pasted the legal citations off the internet from somewhere, because the rest of the complaint, to be charitable, is less than clear in terms of the sentences and structure and what they're actually complaining about. So, I mean, I can add it together and figure it out most times, because I do this every day, but then others are just nothing like that, and it appears to be truly 100% either handwritten or typed by a consumer. So it really does vary complaint to complaint, but I would not say that there is a rash of identical complaints coming from either very sophisticated consumers or lawyers representing consumers.
Complaints that we're getting from the consumers are that they're not licensed. Do they have any other underlying issues with the collection agency? They're threatening something they can't do, or are they?
From time to time, they do. For example, on item number 4, if memory serves, the complainant also mentioned that they were threatening a lawsuit, which they don't have a license. They're not supposed to be collecting anyway, so that's kind of above and beyond. But on complaints that are more serious in terms of their allegations, for example, either pay this in 2 hours or I'm gonna throw you in jail, I'll mention that specifically because that's a separate standalone FDCPA violation, licensee or not, and that's something that I would recommend the board take as strong action as they can against things like that. But typically, for the most part, it's folks calling in and consumers, hey, I don't want to pay the debt, or I don't think I owe it, so let me look into this company a little bit, and if I'm going to file a complaint, oh, by the way, here's this verify license tab, and so toss in unlicensed conduct into the mix for, in addition to whatever else they are not happy about.
I guess what bothers me is that we have an individual that complains that this license to collect, but how many people actually is this company attempting to collect from? Or is it collecting, we just get a complaint here and there, or
I would say it's more a complaint here and there, because the overwhelming majority of the time, I don't want to say it's errant placement necessarily, but But it could be, because I think if it were more than that, then I would be seeing the same frequent flyer folks, the same out-of-state unlicensed entities, and, you know, if they're in here once and, you know, we hit them with the cease and desist letter and I don't see or hear from them again, then I think it's pretty much accomplished its objective. But if they come back a second or third and beyond time, then that's when it's time for stronger action in the form of civil penalties.
So if you get more than two people complaining about the same same unlicensed activity,
Sure.
then there's a bigger problem that we'll look
If
into.
it's, you know, kind of like the first go-round on the surety bond and no prior complaints, you know, we try to go with a letter of warning to let them know, hey, look, this is important, you need to fix it, and don't be back here again for this. The cease and desist letter is kind of the same thing, to say, hey, look, you don't have a license here, you need to cease and desist and stop what you're doing. And if you do that and you stay out of Tennessee until you get a license, then we don't have any additional problems. But if you're here a second or beyond number of times, then, you know, you're going to start getting rung up for civil penalties for that.
Number 10, does he have a license now?
It does not, based on the dates, it doesn't appear so, because the Collection Service Act provides for late renewal of up to 60 days beyond the expiration date of the license. And I actually drafted this recommendation language prior to the 3/3/14 date that's referenced in there. So it, you know, now that it's past 3/3/14, I mean, I'll double check before I send the letter just to make sure something didn't come in before that date. But if not, this particular entity is beyond the period to late renew its license, and so if they wish to continue operating, they're going to have to do a new application.
They've been in business since 2012. They've been in business 12 years. And
Right.
for them to just let it go, is there a process that you go through to, you're hereby revoked, or do you send them a letter? How do you?
Well, in this, you know, in this case, since they are now beyond the late renewal period, they would get a cease and desist letter because they're just like any other unlicensed company at this point. And so, once,
So you're assuming they're still doing collection work?
I think if they've been in business for 12 years, that's probably a reasonable presumption, but there's no evidence of that in the file, and no other complaints of collection conduct for this entity post 3/3/14. So, you know, give them a cease and desist letter, and if, you know, most companies that end up past the late renew period, if they have done business for a while, that will usually jolt them into action, and they'll come back and pay the money and get licensed and move on.
One more.
Sure.
Number 7, do we ever go back and look and see if a company like number 7 is doing any advertising or still actually doing collection work?
Actually, we generally don't, and especially for number 7, they're not quite to the beyond the late renewal date yet. So even though they are late because they still have the right to come back and renew within those 60 days, I think it'd be hard pressed to make something, a complaint like that, stick. Maybe unlicensed conduct or collecting post that date would be a little different, but to be honest, the Collection Service Act is more silent than not about advertising specifically. Now, I think arguably Section 105 that says you can't operate, commence, or what have you, I think advertising falls within the definition of operating a collection service. I mean, if you're advertising your service, then that's part of your operation. So I think that could, you know, that would be the section of the act under which such an action would be pursued if it were going to be pursued. But typically it just doesn't come to that because, you know, if they're the folks who are not coming back promptly after the cease and desist letter once they're past the late renew date. Those folks typically are just people who should have surrendered on time before their license expiration date anyway, but didn't do it, and now they've ceased altogether. And so, it's really kind of an all or nothing situation. You're either dealing with folks who are either out of business or have stopped operating altogether, or, oh no, we shouldn't have let it get this far. So, I mean, it stinks that we got this cease and desist letter, but now that we know, let's go ahead and get our application and relicensed and move forward.
Questions?
On 30 and 31, I just, should we also say, in addition to the civil penalty, that they would need to show proof of the bond?
Yes, Ms. Trinkler, we would, and that's a good catch, and I will add that language to the consent order.
Or no other comments, then I will entertain a motion to accept the legal report as amended.
So moved.
Moved and seconded. All in favor?
Aye.
Aye.
Thank you, Mr. Whitaker. Administrative report, Kimberly.
Yes, sir. On tab 3, you will find your complaint comparison report. No, you will notice that there is a slight increase. A lot of that is due to the bonds expiring. I'm happy to report, for the performance measure, we're at 93.40. Closing or referring complaints for legal action within 100 days.
Congratulations. That's
Yes.
excellent.
done.
If there are no questions regarding that report, we can move on to tab 4, which is your budget report. The usual listing of your revenues through 2/28.
Fire.
No, we.
Working, do I need?
There you go.
It's too gentle a touch.
That grandbaby business.
That's right.
Toughen up.
We're on tab 4.
Yes, sir. Just your usual revenue comparison.
Do we know how much money we're going to lose or have lost with not having a collection service manager license?
We did some research last year when that bill was passing through, and I don't remember offhand what the number was. But what we've seen is a lot of collection agencies being licensed globally at a rate of, I would say, a couple a week, which, so more agencies are coming in because of the reduction or the change with removing the manager. So it's kind of made up for the loss. Other questions, or do we want to move on to tabs 6 through 8, some application reviews?
Eat up on it.
I'm popping it. What's the next tab?
Tab 6.
Thank you.
Tabs 6 through 8 are actually application reviews. The one on tab 6, the agency has made application where they have disclosed that they have been denied licensure in other states. Information related to the denials are on page 6 and 7. The board is asked to review the information provided and determine if these agencies are eligible for licensure.
What is your issue with them, Kimberly?
We just noticed that they have several city, the state of Connecticut administrative proceedings for placing paper without having a license. They did state that they've reached a resolution and they're reapplying. A discontinuance in West Virginia, placing an account on a loan that had been previously exonerated, as well as placing accounts through a company that had not yet been licensed. Again, they've reached a resolution, they're reapplying. The state of Massachusetts, discontinuance for placing accounts on previously exonerated payday loans. A resolution, they're reapplying for a collection agency license. And then within the city of New York, they made application for licensure, but inaccuracies and along with other discrepancies and misunderstandings of disclosed pending litigation and regulatory investigations. They're working to provide clarification, and that's all according to the letter that they sent us. And I will defer to Mr. Whitaker as your legal counsel. Those were just that's on face value of what they've told us. So.
The reason that I actually suggested that this be forwarded to the board was simply because of the number of other state issues. On the pro side, it appears that, presuming that the representations in this letter are true, that this entity is handling these things with the appropriate authorities and is making good faith efforts to try to become licensed in the jurisdictions where it needs to be, or where it needs to be licensed. On the potential con side, when you have 3 states plus New York City, where there were issues related to licensure and potential collection prior to having a license to be able to collect in that place, could be indicative of something more. But as this board may recall from at least the last meeting, there have certainly been worse folks with far more dire and not good disciplinary actions in other states before them. So I would say this is sort of a middle of the road thing, and if the board is of the opinion that they're doing what they can to try and be in compliance and want to be licensed where they're supposed to be licensed, then a vote in favor of licensure here, especially from the perspective of having them in the fold so that they can be regulated by the state of Tennessee, and if protection of Tennessee consumers and public becomes necessary, the board would have a license through which to do so. If the board's opinion, on the other hand, is that where there's smoke, there's fire, and unless these folks obtain these licenses, the board wishes to either deny for the time being or defer a decision on these matters until some later date, that would be a suitable decision as well. But that's the board's call, and can go either way.
So the complaints are not tactics, with the exception of trying to collect a debt in Massachusetts that had been barred by the statute. So the complaints that have arisen out of the other states and New York City is because of a non-licensure issue and not a bad guy collection tactic issue.
That's the way it appears, Mr. Chairman. I saw nothing in this letter or elsewhere in the application file indicating that they were facing sanctions or had been sanctioned for unlawful collection tactics. So it really appears that their issues are related to licensure, and if their letter is to be believed, in one state, inadvertent placement of an account in a state they didn't have license yet. So it's kind of where it looks like it is for now.
On the one hand, the letters obviously they're going to put their best foot forward. On the other hand, they have to be commended for being forthright. They just fessed up and have no reason to believe there might be other states they're having problems with because they listed so many. So kind of an offsetting thing. This is their best position the way they described it, but they really did describe it. So that's pretty
I think
straightforward.
the fact that they're applying for their license in Tennessee probably means that they've come to the realization that they have to be licensed if they're gonna do collection work, so I personally feel like that they would meet the qualifications.
Have we checked with West Virginia or Massachusetts? I noticed this letter's dated back in January. If at that point, they should have been granted by now. Can we just check and see?
Yes, absolutely.
That's kind of why I'm on the side of moving to defer, just until we just know that.
Yeah,
Instead of
but
a
since, yeah,
caution.
it has been 60 days, generally doesn't take much longer than that. I mean,
If you just knew that, I'd feel better
Yeah,
about
if
it.
we just knew that.
Would we say that in fact, if they have, then we would approve it pending that? That way we don't have to wait 2 more months for them to get another license?
That's fine.
Fine with
Because
that.
if the staff determines that, because
Yeah, I think
our
that's
council's
fair.
viewpoint that it's better to have them licensed in the state so we can manage them than possibly running around causing problems unlicensed is both novel and interesting. It does make sense in a way, although it's almost counterintuitive. So
Fine, make a motion to
yeah.
that effect then.
I would move that pending examination with the 2 states that you requested, and if they have in fact cleared with those states, then we go ahead and issue a license.
Just to be clear, is the motion that if they have in fact applied or if they have in fact obtained licensure in those states?
Up to you, ladies.
I do have one, there's actually 3 states. Do you want all 3? Because you've only mentioned 2 so far.
Oh, this is
Connecticut.
City
I
of
mean,
New York.
In Connecticut.
There's Connecticut, West Virginia, Massachusetts,
Oh.
and City of New York, they're providing clarification to them.
I would say, let's just say the 3 states.
Not the
And-
city of New York.
Yeah, it sounds
Yeah.
like that's another
Yeah.
issue.
And Connecticut is a difficult state
Yeah.
at best. Connecticut, yeah, so
As
I'd
you will
almost
see
leave
going
them out and
forward.
just go, if they've done 2, then that would be enough for me personally. Massachusetts, also a difficult state. You almost don't want to be in Massachusetts and collect. But that would be my suggestion. If you feel otherwise, I'm fine with it. I'd amend the motion however you suggest.
They apply as a Frontier Financial Group or North American Asset Management. Letter from, on their letter, it states that the issuance of a discontinuance is a result of the client North American Asset Services, DBA Frontier Financial Group.
Yes, sir. The way it's listed on their application is North American Asset Services LLC. There's not a DBA listed.
On page 2, it says other agency names operating under DBAs, et cetera. So it says both names on page 2 of the application.
But I think if you go to the letter on pages 6 and 7, they're saying DBA Frontier Financial Group, so that may, I mean, I think we have to take them at their word when they're requesting the application from us. If the board feels differently, that we should also ask whether they intended to DBA as Frontier here as well, considering that that's how they're listed in all of the other states. Just so that there's no confusion when and if they do obtain a license, if they start going out as Frontier Financial Group, if it's not listed in the DBA that is connected to the North American Asset Services name, then you could be looking at some confusion to the public as to whether they have a license or not. So in addition to however many states you want to ask for, it might also be worthwhile to place a call to their point of contact here, whoever that is, I don't know, but it's on here, and just ask them, hey, so just to be clear, are you guys going to be just North American in Tennessee, or are you going to be North American DBA Frontier as well?
Do we have that DBA option here?
There
So
are-
you could call, I could send, if I was a collection, if I was these folks, I could send a collection letter North American, and I could also send a collection letter Frontier. And be,
My take on that would be that if you're going to be doing business as some name other than what's on the license, then you need to have that DBA name on the license. Otherwise, it's potentially misleading and the like. And there are there are a fair number of agencies, and actually there's one on this report, I think, item number 1, that entity goes by its name, LLC, DBA, something else. But the DBA something else is also in their application file. So when you when you go look for their application, it's all in one place and you can see it. So you're not confused as to who it is and what they're doing.
I think a call to the point of contact with this agency, and you may even ask them where they stand with the other 3 states.
Because they may,
With
you
that
know,
phone-
they may have an update for us that could save those
Save a
other
lot
3
of
phone
effort,
calls. Because
yeah.
if they say, hey, look, you know, we've already got licenses in these other 3 places, and I'll scan and email you a copy, then that might be 1 phone call
They
instead
submit
of 4.
verification, that'd be great. In fact, that'd be the best first call. Let's put the work on them. We don't need to check with the other states. If they can't provide proof of resolution, if they provide proof of resolution for 2 out of 3, or 2 out of 4, as far as I'm concerned, then, yeah, to put them in the fold. But the DBA thing does need clarity.
Okay.
Now, that's a really unusual motion. Whoever wants to second
I'll
that.
second that. Unusual motion.
Before we vote, just want to ask the group, do we ever really research or care about pending litigation against the applicant?
They're required to disclose that on their application form.
That being the case, I think you should check Wade versus North American Asset LLC and just see what the status of that case is. I don't see it on the application, but I do see it. I don't know. That opens up just a huge can of worms. If we're going to be checking for litigation on applicants, we don't really have the resources to do that. However, there seems to have been a lot of complaints. Well, whatever. You can read anything online, but just while we're in this discussion, I was pulling both these entities up, and there seemed to be a lot out there online, negative in nature.
Are the complaints because of licensing issues, or are they?
I can't really dig in that deep
Mr.
without.
Hellman, just as a matter of standard operating procedure,
We can't do
please
that.
please don't be researching online. That's our job. If we're going to
Okay.
do that, we'll do it.
All right,
But-
so let me rephrase the question. Is that something as part of there seem to be, there are 3 states that they've struggled to get licensed with, as well as the city of New York. Is it worth doing any other investigation to see if there's any merit to the?
Actually, I think it's much simpler than that, because on page 5 of their application, question 3, sub-item E, says, do you now have any civil actions pending against you or your agency? They've checked yes. But, I mean, the pages in front of you don't have that list unless I've missed it. Let's see. So it could have been just a simple oversight of providing that litigation, because they, provided the letter about the other state licensure issues, but we've seen it before where folks have checked yes, but then they didn't continue reading to give us the stuff, and then we call back and ask, say, hey, look, you checked yes on the lawsuits, where's that part? And they're, oh, I'm sorry, here you go.
Yeah.
And so that would probably need to be part of it as well, and we could just ask the question of them, do you have any lawsuits pending against your agency in any jurisdiction? And if so, please provide a list of those and the status of where they stand.
On their side of it, they could have checked no.
They could have.
I know that.
And then, if we had found out later, if we granted them a license and found out later that they indeed had lawsuits against them, that would give us reason to revoke their license. But the fact is, they could have said no and said yes, lends a little bit to the veracity of the company.
Yeah, no doubt.
I don't feel comfortable right now, and I'm, as you can tell, I mean, on this motion, I just feel that we should defer. There are just too many too many things that you're making me itch on this, and that's all I have to say about it. But
Yeah,
I'll reflect it in my
withdraw and
vote.
restate my motion.
Please.
I withdraw the motion, the previous motion, and would restate it to say that we request the administrative staff to contact this agency and verify that they have received at least 2 of the 3 outstanding license issues be resolved in a positive way: Connecticut, Massachusetts, Virginia, or New York, and further to provide a list of lawsuits that they did not provide, and with that, any normal scrutiny we would do with that list provided. And should the staff, after that examination, feel that there are no other outstanding liabilities, and also clarify the DBA issue, then
You just bring it back in May with all of those findings at once.
it'll be fine.
A motion's made to defer until we do further investigation on the
But
license.
we have all that information in May.
Okay, is there a second?
Second.
Second.
Seconded, all in favor?
Aye. Now, as point of clarification for me, are you saying, because I've heard of this entity before, and that's what made me want to, I didn't know what I had heard, but, the Frontier Financial Group, so I was trying to jog my own memory is the reason, but you're saying that for the purposes of anything we do, we shouldn't, you guys looked at each other immediately and said whatever I just did was not acceptable. So tell me, just guide me,
Okay.
please.
Really, for the most part, the bigger concern is for complaints and/or formal hearings, because we as a staff and a division have seen cases before where during the middle of a formal hearing, a board member has been Googling
I see.
furiously to find things, and then it ended up tainting that proceeding, or at a minimum resulting in the recusal of that board member from the proceedings, because they have now injected themselves and taken it upon themselves to investigate and to consider matters that are not within the evidence presented at a formal. So that's the bigger concern, but by the logic of that same argument applies here. If there are things to be done in the way of investigation and providing documents and information, that is what I, as board counsel, and the staff as your staff, are here for. And anything you need in that regard, please ask, and we will get it for you. And that way, similarly to the formal hearing line of thought just now, everybody is looking at the same thing. Nobody is making a decision based on something that the other board members didn't see. So
Good. That's good advice, and
And when this comes to the board in May, I would suggest, Mr. Hellman, that you recuse yourself, not because necessarily of the internet part, but because you just indicated that you have prior knowledge of this entity. So just to be safe, there are still 4 other board members, which is more than a quorum. And so
Okay.
please feel free to listen, and if there is something that you see on in the presentation, you're certainly free to offer your thoughts, but when it comes time to vote, we would need to do a recusal from the consideration and the vote itself.
okay, good. I will. Thank you.
I do want to include, though, they did include some litigation information in their application. So we'll go back and review all of that. I apologize that it wasn't here. I didn't realize that it was part of the review for this, so my apologies.
How does their financial information look?
I didn't actually review this particular file. Let me find it. Yeah, just on face value, assets and liabilities, the ratio looks good.
They've made money year over year, and as their revenues have increased, their liabilities have increased, but at a lower rate than the increase of revenue. So it looks like they're doing okay business-wise
thank
and have the cash to operate.
If I was to guess, I'd say that they've come to the realization they need to be licensed everywhere, and that's what they're going through the process of doing.
Most likely.
Tab 7 now? Is that where we are?
Yes, sir.
Okay.
And actually, tab 7 and tab 8 are for two separate agency, different locations, but it's for the same entity, so the information on both of them is exactly the same.
What's up?
Okay. Both applications disclose denial of licensure in another state. Connecticut was the state of denial.
Surprise.
we shocked?
And information related to the denial is on page 7. And then additionally, both applications disclose pending litigation, and this is in detail on page 8. The board is asked to review the information provided and determine if these agencies are eligible for licensure.
And I think I can cut some of this down. The litigation disclosures part was fine. I have already reviewed that and, given the size of this agency and how much business they do, I mean, obviously they're going to have a larger number of suits than a smaller agency, but the key thing that I look for in any set of litigation disclosures, actually there's two things. Number one, is the amount of lawsuits relative to the size of the company reasonable? If you got 100 lawsuits, but you're a little mom and pop shop with only 1 or 2 clients, that's different than if you're a multi-state conglomeration that does business all over the country. So there's that consideration. And then the second is whatever the litigation disclosures are they on top of it? Are they handling it? Can they tell us where they are in the lawsuit? Can they tell us what's happening, where it stands, what they've done, if it's final, if it's on appeal, and if they can tell us those things, that indicates a level of responsibility in that they are handling their caseloads promptly and appropriately, whatever happens. And then if both of those pieces are in order, then generally the litigation disclosure will not be a holdup to licensure. Really, just to be safe for items for tab 7 and 8, because Connecticut had previously denied a license, then I did want the board to consider it, but at the same time, it's noteworthy that for both entities, they were able to promptly resolve the issue, and they do now have licenses in Connecticut, which is no small feat. So, not that my recommendation on tab 7 and 8 would be for approval, but anytime there's an issue of denial of license in another state, no matter how relatively small, I will typically err on the side of bringing it to the board to look at and consider in the event that the board has concerns that I've not seen or addressed.
This agency appears that they are a mortgage servicing company. And they've just decided that they need to be a collection agency across the country, or just in Tennessee, or Connecticut and Tennessee?
Well, Mr. Chairman, one of the trends that I've seen over the last year or two is a fair number of mortgage servicing companies going ahead and getting licensed, even though they are primarily regulated both by the federal government in various ways, and even, like in the state of Tennessee, mostly through financial institutions. But and this is just, one man's take and opinion based on what I've seen and the complaints coming in for those kind of entities, but I think they've made a business decision that when they go to court to try to file suit on, delinquent or foreclosure mortgage actions, they don't want to have to deal with the defense of you're trying to collect from me and you don't have a license. And by paying what is a relatively small amount of money in the grand scheme of things, and for most of them, they have more than enough financial wherewithal to operate and meet the financial responsibility requirements in Tennessee. It's like, hey, for the bargain price of this application and surety bond premium, whatever small amount that is, we can cut off a potential line of attack in our foreclosure lawsuits when they arise, so that we're not delayed 6 months or a year or 18 months or however long on the basis of a defense that we could fix for such a relatively small investment.
Now that they don't have to have a collection agency license and take a test that we don't have available for them, they're licensing. I think that.
I'm reading this report properly. There are about 40 pending lawsuits.
That's correct. And just by way of example, if you look on the, report itself, they list their active litigation. They have the name of the plaintiff, the state in which it was filed, list of defendants. Sometimes it's just them, other times it's other entities as well, mostly within the, chain of mortgage servicing. Date of the lawsuit, complaint filed, court docket number, next line, the nature, contested foreclosure, RESPA, fraud,
Right,
other
right.
and you just go on across the line, and even a layman who knows very little about lawsuits could at least have a working, functional idea of what's going on in each case, and that's indicates that they are handling their caseload appropriately.
Well, just as a matter of record, I think there are 982 lawsuits filed in the month of January against collection agencies and creditors. So more and more we're going to see this on applications. And I think the key is, for me at least, is that they've properly disclosed and given you a nice, chart of all those suits. So that
Is
makes
tab
sense.
8 a different name, or can we move that we approve 7 and 8?
They're just different locations.
Different locations.
You can do one
Same-
You
motion.
can do one motion.
Okay. I'd entertain a motion that we approve tab 7 and 8.
So moved.
Moved. Any seconds?
second.
And seconded. All in favor?
Aye.
Okay. 9?
Actually, this will actually be listed as balance sheet information.
Oh, boy.
And I know this is a topic that has been reoccurring. I'm actually going to defer to Mr. Whitaker on this discussion.
And I, in turn, will mostly defer to Mr. Hard, but I will be glad to work with him as appropriate to make any changes necessary to the balance sheet. Due to other matters, we weren't really able to dedicate the time that we would have liked to this discussion, and so we just had the balance sheet document itself.
Before we get into that, could I adjourn for about 10 minutes?
Yes, sir.
Certainly.
Okay. Thank you.
Thank you.
I drank too much coffee on the way up here. Just kind of rented,
Can I speak to you while we're adjourned?
Sure.
One thing's for sure, I'm not surfing the internet.
We'll reconvene the meeting of the Collection Service Board. I think we were on tab 9? 8, sorry. No, that was, we
Voted-
finished, we voted 8.
Voted
On
eight.
9, yeah.
So we're on 9 now.
Well, it's actually, I entitled it balance sheet.
Okay, balance sheet. That's on the agenda.
But I believe Mr. Harb has provided some additional documentation.
It's a very generous description of what's been provided. But I think it's, let me see, tab 9 does have a picture of the balance sheet on it, which is, what I've done is I went to the website and printed off the financial statement, which is the same as the balance sheet that I think we have pretty close to it. And my suggestion is to alleviate the conflict that we have in getting CPAs to do this, but also it's important to me that we have our applicants go to outside counsel to get proper financial information or have a CPA prepare it. My concern is with the form the way this is, that what could be happening is they'll prepare it from their own internal records and just provide the name or the information of the CPA. Nowhere do we really have a CPA's signature or a letter or know that a CPA really looked at it. Because when I look at this, my public accountant's information is provided below. It doesn't say my public accountant or my CPA saw it. So I'd like to make sure they at least went to one. Now, I don't believe our requirements say that it has to be compiled, audited, reviewed, or prepared internally, but it just says that a CPA licensed has to sign it and provide the information. So my recommendation is that we minimize the financial information we request on our form. And our form simply would be assets, and then we have the lines cash in bank for trust, cash in bank operating. Then we have all other current assets without going into the form of a financial. The only disclosure that we have them articulate on our form would be the cash in trust, cash in operating, total assets, then due to clients, and then if clients are not owed anything, explain, and they can explain on the face, total liabilities, total equity as a single number, and then total assets and liabilities that should match. Then with a further statement at the bottom that says, attach a financial statement prepared by a CPA, prepared and signed by a CPA, with the license number and address of the CPA included. We don't want to define the type of report the CPA has to give because depending on the size of the firm, these could be audited financials, compiled, reviewed. In fact, they could be internal financials if they have a CPA on staff who is a licensed CPA. They could sign it and write, I have prepared this in my capacity as a treasurer, CFO, controller of such and such entity. That complies with our law. Now, clearly it's an independence issue, but a CPA has prepared it, and that's our standard. So that way we don't try to have all this financial information provided and put in a form. We just get the pieces we've got to see for application approval, get the CPA's full financials, and that makes them go to a CPA to get it done, which is not the standard right now. That's it, Elizabeth.
So you're proposing that this financial statement that we're looking at here be prepared by the agency or the
Yes.
CFO at the agency or what have you, and then in addition to that, a compilation report or audit or a review or whatever it might be, any kind of a report prepared by a CPA, and then they have their rules to go by.
At the bottom of the financial, we'd have a legend, just like we have all these other type writings, applicant's affidavit on page 2. It would say, attach a financial statement prepared by a CPA that would match total assets and liabilities that are written in. So they just have to go and find their cash accounts and their due to clients, because that's what we want to see. Are they in trust? And then it matches what's attached. Then we can use what's attached if we want to get deeper. But we get a proper CPA signature, and we know we forced them to go to a CPA to have it done. And it just alleviates the entire abomination of the form that we have.
What are the rules, or are there any rules about how old the statement can be when they're applying for a license with us? I mean, if they brought a 1996 financial statement, would that suffice? No. Okay.
They could make that argument. I don't think it would be a winning one. Typically, what we insist on is their most recent one, whatever it is. So if it's, for example, we're early in 2014 right now, some applicants may already have their financials ending 12/31/13 done. And if they do, that's what we'll ask for. But for example, to build on what Mr. Harb was saying, if this is a larger entity, they still have some time left for their taxes and everything else, and other reports for regulatory purposes have to be filed. So they might not have it done yet. So if their most recent one is, 12/31/12, or, they do a quarterly or mid-year report, maybe they have one ending June 30/13 or something. So basically what we would tell them is you provide your most recent completed financial statement.
That's fair enough for larger companies that are going to do that. I know for a smaller company, 5 or 6 people or less working and trying to collection agency, having a financial statement prepared by an accountant is quite expensive. They should have one every year.
Therein lies the issue. And I do not want to sound in any way arrogant to the board, but there comes a point at which if they are not adequately funded or responsible enough to have their numbers prepared on a routine basis by an outside party, then do we want them collecting in our state? Is that a
Routine-
standard?
Routine being once a year, or?
Well, we
quarterly?
only, this is, the application is only once a year, so, yeah. I mean, it doesn't have, we're not specifying the standard. It doesn't have to be compiled. A compilation with no footnotes is not that big a deal and not that expensive.
Well, I agree that if we have somebody applying for a license that can't afford a once-a-year compiled financial statement prepared by a CPA, we don't need them as a licensee.
And if, that's, I agree.
don't think that's overbearing.
No.
This doesn't seem onerous. It doesn't.
Simplifies what they give us. We see what we need to see as a staff to know that they're in trust, and they're attesting to that they're in trust when they sign the affidavit. And then we have the financial statement. We take the pressure off the CPA, who can actually give us the information in a format that they are permitted to under their rules. It just makes the form cleaner and easier.
Are you with it, Chris?
Actually, what Mr. Harvest proposed looks pretty solid, and obviously it would not be in the handwritten chicken scratch format you have now, but I'd be happy to, if the board approves it, work with the staff to boil this down to a new form to bring back in May for the board to look at, and if it's acceptable at that time, then the board could vote to use that new form going forward.
Does our statute provide that we shall provide a form to be completed?
The standard language for most regulatory programs is applicants shall complete an application form as proscribed by the board. And so that's pretty wide latitude and discretion as to what you ask for up to a point. With some of the things that we've heard from the current administration and down the line from the commissioner's office and the assistant commissioner's office is basically get the information that the program needs to do its job and to regulate as necessary and to make sure that they know what they need to know, but no more. And so if it's not specifically called for and provided and the board doesn't need it, then try and stay away from that. But, short of that, the board has some leeway there.
What we need to know is that they're in trust, they're aware of it, that they have adequate net worth, and that will be in the attached financial from the accountant, and that we have an accountant's report. We have to have that. I think we're required to have that information, so it gets all of those things.
Other discussion, is there a motion necessary? Chris is going to come back to us in May with a proposed,
I would just phrase it as a motion for staff to amend and update the financial statement form currently being used to bring back to the board in May for consideration to use the changed and updated form as discussed at this meeting.
Second?
and seconded, all in favor? Aye.
Aye.
Okay, thank you.
A job well done, Mr.
Absolutely.
Harb.
And quickly. Legislative update. Kimberly.
My mic on. Greer Kelly, one of our legislative liaisons, was unable to attend the meeting today. I will give you a brief update, but I have spoken with her, and we will follow up with a formal email probably by the end of the week, early next week at the very, very latest. But you did previously receive via email her update about two pieces of legislation that are currently working through the legislative process. Senate Bill 2291, it is not currently on calendar, and this bill was related to the Class C misdemeanor, I believe. Forgive me if I misspeak on which letter of the alphabet there. But it does not have a companion bill and is not on calendar. So I believe at this point that bill is probably that particular bid is probably dead, but it may be a caption bill. But not having a companion at this late date. But we will get the formal update from Ms. Greer. Senate Bill 2133, House Bill / House Bill 1856. This is the piece of legislation that would change the narrow down who is required to be licensed. And that, based on what I can see online, has passed the Senate and is headed to the House. There has been one amendment to it, and that in her report that she updates from her original as to what the amendment did.
And also, when you get that email, please don't email each other. Just call me if you have questions, because we don't want open meetings violations by email or phone or otherwise. I know you guys all know that, but would rather mention it just the same.
Thank you, ma'am. Is there any new business?
I do have one announcement for you, which actually dovetails with what Chris just said. At your next meeting, we will have a presentation from the legal division related to the sunshine laws. It'll be about a 30-minute presentation. And I wanted to ask the board's opinion, would you prefer to do that at the beginning of the meeting before your business, or at the end after you've completed your business, so that I can schedule that? Like it at the beginning? Certainly. I will schedule legal to appear at 9:30 a.m.
Any other announcements or any other new business? If not, we'll stand adjourned. See
Thank
everybody
you.
except me.
Meeting is on May
14th.
14th.